Welcome back to Kapowich on Real Estate. We are back in the studio with Kent Westerberg, real estate attorney. Kent, welcome back.
Pat, good to see you again.
Long time no see. Okay, with all the real estate cases that are out there, oftentimes I'm told they have a lot to do with seller disclosure.
Absolutely.
Okay, so let's get into this. I understand it's most of the real estate cases that we have. So with the transfer disclosure statement, which is the mandatory 3-page form throughout the state of California,
Right.
agents often drop it off at the house for the seller to fill out, and then the agent will either come back to pick it up or the seller is instructed to mail it in. Can you talk about how to fill out a transfer disclosure statement?
Well, one, I don't think it's a good practice for realtors to just drop off the real estate transfer disclosure statement. It's something that's required by law. Realtors have a legal obligation to explain that document to the seller, go through it with them, because it's a very important part of a real estate transaction. The seller is obligated to disclose everything that they know that would materially affect the buyer's decision to purchase the property or that would materially affect the value of the property.
Right.
So it's very important for the realtor to go through that document with the seller and explain it to them, explain the significance, explain what it is that they're disclosing, and then the seller is to go through it and make all of the disclosures. In the 3-page TDS, it itemizes various things you need to disclose. If there's reports that have been done on the property, disclosure reports, appliances, what are working, if there's been any problems with the property. And if there is anything like that, the seller is supposed to provide some sort of explanation. And then on top of that, the listing agent, that is the agent that's representing the seller, that agent also has an obligation as a matter of law to do an inspection of the property and then also make a disclosure that's in that document about what they see as any problems with the property. And the buyer's agent also has to conduct an inspection and fill it out, and then it's given to the buyer to apprise the buyer of any problems with the property. Okay,
now speaking of that, when the agent, the seller's filling the form out, one, it has to be in the seller's own hand.
Absolutely. It is. A listing agent should never, and I've seen this done before, it's only going to be problems for the listing agent. The listing agent should explain it to the seller, and the seller should fill out their portion. The agents fill out their portion. The agent should not fill out the seller's disclosure. That is the seller's obligation. And I know a lot of times agents, they want to do as much as they can for their clients. Clients will say, look, I'm very busy, I don't have time. But they need to tell them, look, this is something you have to do as a matter of law. It's important. It's very important. You need to fill it out. They just need to explain it, and they should insist that the seller fill out their disclosure.
Okay, now at the top of that form on page 1, it speaks about whether the seller is living at the property or not.
Correct.
And if they have any reports, past or present. Oftentimes people forget about the past transactions.
That is true.
From prior sales. Can you speak to that?
Absolutely. You know, the law is, well, let me state this, that it will not bode well for a seller to not make a disclosure about something and subsequently say, I forgot. The seller can still get into trouble. There's something called rescission. If a seller doesn't make a disclosure and it turns out to be material, a buyer may have the opportunity to rescind the contract. That means give the property back, they get their money back. And in California, as a matter of law, even an innocent misrepresentation will support a rescission. So, you know, a seller should not, has to think if they are aware of previous problems, even if they're 5 years old, 10 years old, they should be making those disclosures. If the roof was repaired, if there was a retaining wall that was fixed, if there have been subsidence or settlement issues on the property, even if they've been repaired, even if they're 5 or 10 years old, they should be making those disclosures. So if there are previous reports, you know, I always advise clients, err on the side of disclosure, because if you don't and there's a problem at the property, it could come back to bite you.
Okay, because that's, it's often said with the veterans that if the buyers are informed up front, they're given a pass. It's when they find out during the sale or after the sale, on their own or from the neighbors, that's when perhaps
Absolutely.
cases occur.
No, and that's another good point that you bring up. If the seller makes the disclosure, provides the real estate transfer disclosure statement at the very beginning, before an offer is made, before a contract is signed, the buyer doesn't have the automatic right to back out of the transaction within 3 or 5 days, depending on whether it's personal delivery or mail delivery, when they get the transfer disclosure statement that the law provides. If that disclosure is given at the beginning, the buyer can't back out, and there's a reason for that. The buyer's being informed before they make an offer. Here's our disclosure. Now, it's different if a contract is signed and a few days after the contract is signed, the seller then provides the real estate transfer disclosure statement. The buyer has an ability to back out of the deal within 3 or 5 days because of anything that is disclosed in that disclosure statement. So what a lot of sellers and listing agents do is they provide the TDS, the disclosure statement, at the very beginning before an offer is made, so that then the buyer can't back out for some reason that's in the disclosure statement.
Right.
So if it is given at the very beginning too, the buyers really need to take a look at it.
Okay, because years ago that was a gotcha for the buyer and the buyer's agent.
Absolutely.
And then over the last 2 or 3 booms, a lot of listing agents learned that if we give them that 3-page disclosure up front, they cannot cancel the sale later.
Exactly, and it's good practice. And what the good listing agents will do is they'll say, look, here is the disclosure package. Give them the reports. Here's the TDS. Don't bring it back to me. Don't give me an offer until you come back to me with all of this stuff signed, showing me that you've given it to your client. That's the good practice.
Okay. Now, that said, that does not negate the inspections or inspection period, which would be a good idea to give a buyer.
Right, and absolutely. What you're seeing, and we still are in a very hot real estate market in Silicon Valley, and inspections are important. And a lot of times, properties still go, competing offers, multiple offers above list price, and one of the areas that concerns me a little bit is some buyers are so anxious, they want to offer either all cash or they want to offer no contingency, we'll buy it as is, we'll close in a couple of days, we won't perform any inspections. They shouldn't be doing that because you need to inspect the property. You're making a significant investment.
Now, on that note, depending on the market, because this show may occur when it's more of a balanced market or, for instance, buyer's market, if you have a nice property and it's priced well, you will still have multiple offers, and you will still have people bidding over list price.
Sure, yeah.
And still using these tactics to get the sale accepted, the offer accepted. Now, for instance, I know a lot of companies, we spoke about this when the show began in '99, that if a buyer's agent comes in and says 0 days for inspections, bad idea for the seller. Seller should counter back, allowing the buyer 3, 5, 7 days to cool off, get their inspectors out there, and then remove their contingency.
Absolutely. It's a problem for both sides. You want to be able to, sellers want to sell the property as quickly as possible. They want to get as much money as possible. Buyers want to get it for as little as possible, but they want to make sure that they get the property. And that's where agents need to talk to them, advise them. You got to be a little more cool-headed about this.
Right.
You don't want to get into a situation where you're not protecting yourself, because a lot of properties have problems with them. And it's very important that the buyers have the opportunity to inspect so that they can make an informed decision, so that there aren't problems afterwards and you don't end up having to hire someone like me because you bought the property and find out there's problems.
Okay, let's put pieces together. There's a contingency period where the buyer says, I will buy the house contingent upon this happening or the loan happening. And then the transfer disclosure statement, the TDS.
Right.
And then just the buyer changing their mind. Oftentimes the buyer thinks the next day that they could cancel the sale, change my mind. Can you speak to that?
Sure. You have contingencies built into a contract to give the buyer the opportunity to back out of the deal if things don't go as they plan. In other words, you have a property inspection contingency so that you can inspect the property And if you discover problems, before that deadline, you can back out of the deal. You have a loan financing contingency, because if you can't get the loan that you need, you can back out of the deal. But too often, I've seen it happen. People think, well, oh, what's a day or two? But they fail to pay attention to the fact that contract says time is of the essence. That means that, deadlines are going to be strictly enforced. You cannot wait. If your deadline is November 15th to back out of a deal, or to remove a contingency, don't wait until the 16th. You have to make sure that you do what you're going to do, what you have to do under the contract before you remove your contingency, or you can get into trouble. And just to finish up on that, in other words, sometimes buyers decide that they don't want to proceed with the transaction and they do it too late. They are risking, because in most cases, buyers initial the liquidated damages provision. And if they try and back out of a deal after they've lost the right to, in other words, the contingency period has expired, they run the risk of losing their deposit as liquidated damages to the seller. And if they haven't initialed the liquidated damages provision in the contract, they could be subject to even additional higher damages that the seller incurs, because they now have to sell it to somebody else, and they sell it at a loss, and then that buyer's on the hook for those damages.
Right. Okay, so that, to clarify on the contract, when the buyer, the next day, he overbid, for instance, in any market, and then says, I changed my mind, can I have my check back? It doesn't work like that.
It does not work like that, no.
Now, in terms of the deposit, can you speak to that? Because that buyer's agent, who was employed by the buyer, cannot bring the check back and hand it to the buyer anymore. It's out of his hands.
No, that's right. And what's supposed to happen, the contract specifies a deposit. There's supposed to be, and it specifies a time period for getting that deposit into the title company that's handling the escrow. That check is supposed to be obtained by the buyer's agent, deposited into the escrow. And yeah, if a buyer decides right afterwards and they don't have good reason to back out of the transaction, the seller has done nothing wrong, and the buyer is trying to back out when they really don't have the clear legal right because they've missed their contingency period, they run the risk of losing that deposit up to, and the contracts in California provide this, up to 3% of the purchase price. They run the risk of losing that to the seller.
Okay, because they're stating up front in the contract that this is how much money I will put at risk if I default.
Exactly.
Now, that said, the buyer typically will have a contingency period. I will buy the house contingent upon my inspections. And if they cancel within that period, they get the deposit back.
Right.
However, if they mention to the realtors or the seller, I changed my mind, that's a problem.
That is a problem. You can't just back out of a transaction because you change your mind.
Right.
If you're backing out because you're exercising your right under a loan contingency because you can't get the loan, you're entitled to back out.
Okay.
But you can't make up something. You have to, the buyer, their reason for backing out has to be a legitimate one, and it has to be one that's protected under the contract. In other words, it has to be one of the things that they built in a contingency for to back out in the event there was a problem.
Right, okay. Now, with that said, we have the forms committee. This is the forms for California Association of Realtors, and then
Right.
our local PRDS
Right.
forms. In fact, I'm on that committee. I was there today with our new transfer disclosure statement, the supplemental. Now the California Association of Realtors came out with a supplemental statutory disclosure, and that is the seller supplemental disclosure.
Right.
Can you speak to that?
Sure. What both PRDS and CAR have done is they have added to the 3-page statutory, legally mandated disclosure statement. And I think the CAR form is about 3 or 4 pages. The PRDS form, I think, is 6 or 7. It's not required as a matter of law, the supplemental disclosure.
Right.
But basically how both the PRDS and the CAR contracts are drafted now, they basically say, if you're going to use this contract and you issue the transfer disclosure statement, you have to use the supplemental disclosure. So in a sense, you have to use it anyway. And I highly recommend it. If it's not used, it could be a problem for the seller. It could be a problem for the listing agent. And again, it's all about making sure that the buyer is fully informed when they purchase that property. And the supplemental disclosure, I do think that eventually the provisions in the Civil Code are going to be amended to include these supplemental disclosures. It's a good thing. It's forcing the seller to make even more disclosure about the property.
Correct.
The statutory required 3-page TDS only has the seller disclosing certain information. The supplemental disclosure adds to that, and it makes clear to the seller, the way it's drafted, that they not only have to disclose problems that they're aware of, but even previous problems and even problems where they've made repairs. Because what I've seen in a lot of cases that's resulted in litigation, sellers haven't disclosed previous problems because they'll say, oh, well, it was repaired. We didn't think there was a problem.
It was fixed.
Exactly. And that's not how it works, because sometimes when you thought it was fixed, it wasn't fixed. The problem comes back. And again, it's a good thing because it's all about making sure that the buyer is fully informed. And with the supplemental disclosure, the buyer now will be informed about previous repairs, so they can look into that, ask additional questions, make sure that they know what they're buying.
Mm-hmm. Because sure enough, the neighbor will come over and say, oh yeah, Bob had a problem with that all the time.
And I've had cases like that where, boy, I could tell you stories. Where I had one particular case where no problems with the property were disclosed of any kind, no flooding, no drainage problems, no subsidence problems, and literally the day after escrow closed, the president of the homeowners association came over, visited with the buyers and said, welcome to the neighborhood, but hope you enjoy your property. You do know that your property is the main drainage path to the golf course, which hadn't been disclosed, and there had been previous flooding on the property, and sure enough, it was a problem for the buyers. So that's an example of where, not a neighbor, but somebody who the day after escrow comes over and identifies a problem that hadn't been disclosed by the seller.
Well, that brings up a good point about, we started with the transfer disclosure statement that the seller has to give to the buyer.
Right.
And that the agent should help that seller fill that form out, because in that form, if there is absolutely no repairs or defects and everything looks rosy, something's wrong. Certainly somebody did some repairs somewhere.
Yeah, usually. I mean, it depends on the property. I mean, there's some properties in Saratoga, Woodside, Atherton, Los Altos that are 80 years old or more. And sure, those properties are going to have problems. But, then you can deal with problems in Silver Creek in San Jose, which are brand new. Those properties aren't going to have had as many problems. And so it's not unusual to see disclosure statements with properties that, with newer homes that don't have problems.
Right.
So it depends, but it is important. One, it is the realtor's legal responsibility to explain that document to the seller, and for the seller to fill it out completely and truthfully. I mean, Pat, I could tell you, I've seen cases where no one's paid attention and the seller hasn't completely filled out that document for whatever reason, and that can lead to legal problems.
Sure. Well, for instance, if it's not completed properly and it's caught on day 15 of your sale, then, and I've done that as a buyer's agent, I send it back to be filled out completely, and once we get it again, the buyer gets it again, he has another 3-day right of rescission. Exactly,
and again, you bring up a very good point. A buyer has, again, 3 days if it's hand delivered, 5 days if by mail. Whenever during the escrow process they are informed about something that would materially affect the value of the property or their decision to purchase. So in the example you just gave, if the TDS has not been properly filled out and it's given again, that does trigger a brand new right of rescission to the buyer. And the same thing works, it doesn't have to be a TDS. The seller may suddenly remember 2 weeks into the escrow, and after he's provided the transfer disclosure statement, that he did some repairs, or he remembers some problem with drainage on the property, or a problem with water coming in through a window or something, and he decides to disclose that. As soon as he makes a material disclosure like that, that too triggers a new 3 to 5 day right for the buyer to back out because of
Wow.
that disclosure.
Wow. Now, speak about it on page 3 of that document. Each realtor has to walk the property and look for red flags.
Right.
They just can't write in there, realtor recommends buyer getting inspections.
No, and that's a good point too. A lot of realtors do that.
Sure.
Their job and what the law requires of both the listing agent and the buyer's agent is to go through the property. They have to conduct a visual inspection, a reasonably competent visual inspection. They're not obligated to go down and go through permit files.
Correct.
They're not obligated to check for lawsuits. They're not obligated to crawl underneath the house and do things that some other expert might be required to do. They are just obligated to look at the house. They're held to a higher standard of care because they're real estate professionals.
Right.
They're held to a higher standard of care than a typical, just a lay person. But they're to go through the property, look at it, and if they see something that would constitute a red flag, water coming in, water stains, sloping floors, stuck doors, they are to make that disclosure just on a factual basis. And they have to do that. And if to just put in, conduct all inspections, they are not satisfying their legal obligation with respect to both their inspection and their disclosure obligations.
Right. And that's where lawyers will often say, well, Mr. Realtor, didn't you just break the law there?
Right. Well, and
Right.
it depends. They may have done two things wrong. They may not have performed the proper inspection, and they may not have performed the proper disclosure or done the proper disclosure that the law requires.
Okay, that reminds me of the California Real Estate Solutions Lawyers, Liars, and Litigation representing sellers, Lawyers, Liars, Litigation representing buyers. I was on this committee for their checklists, and I want to dedicate that to the people that are unable to tell the truth.
Right.
Now that said, realtors do not have to go off-site.
That is correct. That's the law.
Okay, now, however, if a realtor worked that area in the situation that you mentioned, worked that particular golf course or whatever it is, and he noticed, always turn your cell phone off when you're on a show, and they noticed that that house was being sold, and they knew that the water goes through there, they had knowledge, so they should be able to disclose that, right?
Absolutely. I mean, if they have any knowledge, doesn't matter when they acquired it, how they acquired it, whether they acquired it when they weren't representing the seller or the buyer, if they know something about that property, either because they've lived in the neighborhood, yes, they got to disclose it because it's their personal knowledge. And if they're aware of problems, they need to be disclosing that.
Okay, what about the sellers who are unable to tell the truth because they feel that they may their property look in a poor light? Can you speak to that?
Well, yeah, I do come across that where sellers are concerned about how much to disclose, what to disclose. I get phone calls all the time because they're worried if they disclose too much, they won't get fair market value, won't get the price that they want. I tell them, you know, you're not supposed to be making conclusions, giving opinions about your disclosure, but if you are aware, but you have to disclose facts. If there have been repairs of a significant nature, if there have been material problems, you need to disclose that. I mean, you are running a huge risk if you are aware of something and you don't disclose it and you think, well, I don't think it's a problem or they're not going to learn about it. You are running a huge risk.
Mm-hmm. Okay, so we have people that perhaps may massage the truth or be unable to be honest on these documents. That's prior to the sale. Then let's say that there is a problem and it goes through mediation, arbitration, litigation, and you learn that people were just flat out untruthful. And as an attorney, basically you depose them and find out that they were basically...
Good point. And I've had that happen. I've had cases where at the outset of the case, the seller says, look, we disclosed everything that we knew. There wasn't any problems. And then we find out in discovery, reports are produced, or we find out through the deposition of other people, contractors, oh, I was out there.
Twice.
And I was out there twice. I fixed the problems. I told the seller about it. The seller knew about it. And then suddenly the seller goes, oh, right, I forgot about that. When that happens, it's a problem for the seller because, as I said earlier, they could end up with a finding of fraud against them. Innocent misrepresentation will support a rescission or a claim for fraud damages in California. And so a seller runs a huge risk by either trying to not make full disclosure or incomplete disclosure. It can come back to bite them, not only with actual damages, and generally the measure of damages in these sorts of cases is, what was the actual value of the property at the time escrow closed compared with what the buyers actually paid. But on top of that, if it's found to be intentional, they can get hit with punitive damages. Sellers, and as important, there is an attorney's fees clause in both the CAR and the PRDS contracts that say prevailing party gets their attorney's fees, which means, if there's litigation and the seller finds out afterwards, heck, didn't make the disclosure I should have, they may not be able to get out of the litigation without paying the other side's attorney's fees. And if they don't, and they go through a trial, they may have to pay not only their own, but the other side's.
Wow.
So it can be a significant damage problem for a seller.
Now, oftentimes their insurance company will pay the bulk of the claim, correct?
Well, it depends. You mean in the situation of when a seller's sued?
When a seller's sued and caught lying through their teeth?
No, on the contrary. I mean, it depends. Generally, there's no insurance coverage if there's intentional wrongdoing. Even an umbrella policy is not going to cover that.
Wow.
Homeowners insurance, generally there's not coverage for those things either. It has to be negligence. There's not coverage for breach of contract. But generally in non-disclosure cases, there isn't going to be insurance coverage for a seller to fall back upon.
So it's just like real estate with the real estate agent, their E&O coverage is not.
Exactly,
Great.
exactly.
Kent, thanks for coming out.
Oh, glad to be here.
Stick around, do another show.
Okay.
Thanks again for being our guest tonight. Make sure you tune in next week for another show of Kapowich on Real Estate. Thanks again.